Hello, welcome to St. Peter's Law Academy. Well, the topic today is the basic structure doctrine, a topic of the constitutional law. And in this topic, we are going to trace the journey up to the Keshavananda Bharati case 1973. Well, at the very outset, I must say this, that I have had occasion to speak on this issue in past as well. But every time I get an opportunity to speak on this subject, I happen to find that the style changes and so does the content a little bit as well. So today I am going to present this doctrine before you. I am not going to present, the Supreme Court has already presented it. So today I am going to discuss it, rehash it, right, in a new style with a little bit newer content, right. So the basic structure doctrine, as you are aware, got established by way of a decision of the Supreme Court in the Keshavananda Bharati case 1973. And the basic structure of the Constitution simply means that there are certain important features, certain basic features of the Constitution which are beyond the reach of Parliament. The Parliament, though it has the power to amend the Constitution in any manner it likes, but it does not have the power to amend the Constitution in such a manner as to destroy the basic features of the Constitution. In order to be able to appreciate the whole scope of the basic structure doctrine, we will have to do some introductory sort of work as well. How has the Constitution actually come about? How did it get off to a start from the year 1950? What sort of problems started arising in the initial days of the working of the Indian Constitution? Without getting an idea as to it all, we are not going to totally comprehend the basic structure doctrine. Therefore, let us start our journey from the very inception of the Constitution. As you all are well aware that a Constituent Assembly was set up in the year 1946. And that Constituent Assembly had become a sovereign body. It had the task to frame a constitution for India. And it started its exercise from the year 1946 and it continued its work till November 1949. In all, 2 years, 11 months and 18 days were consumed by the Constituent Assembly to frame a constitution for India. Due to some historical reasons, the constitution got commenced from January 26, 1950. So from January 26, 1950, we have our own sovereign constitution, the Government of India Act 1935, which up till 1950 was our constitutional law, remained no more there. And the Constitution of India started occupying the whole field of governance and fundamental rights, etc. So ever since the beginning of the Constitution, we have seen that there have been some conflict-like situation between the two organs of the government. As is well known, modern constitutions have three organs of government, three great organs of government: the legislature, the executive, and the judiciary. The system of legislature, executive, and the judiciary was there in the constitutional law of Britain as well. As you are aware, Britain never framed a written constitution, but so far as the constitutional laws, the principles of constitutional laws are concerned, they are well defined there in England also. It was the United States of America which for the first time wrote down a constitution, and that got enacted in the year 1789. So be it the English constitutional law or the written constitution of the United States of America, it is uniform provision everywhere that governments have three organs: legislature, executive, and judiciary. In our country also, when British Parliament enacted several constitutional laws and reforms thereupon, a system of legislature, executive, and judiciary were introduced in course of time, and successive constitutional reforms that were undertaken by the British Parliament brought about certain changes in the overall format and content of the legislature, executive, and the judiciary in our country. But there were certain imperfections, deficiencies, drawbacks. That's why the freedom movement raised on. And we wanted a modern government of our own type, of our own choice. And also, we wanted fundamental rights of the American type. And that's why a demand for Constituent Assembly occupied the foreground of the freedom movement in our country. And ultimately, in 1946, the Constituent Assembly got established, which, as I told you, framed the Constitution of India in 2 years, 11 months and 18 days. So from the beginning of the Constitution, we see that we have legislature, we have executive, and we have judiciary. And because our Constitution provides for a federal system, though the federal word hasn't been mentioned in the text of the Constitution at all, but in practical sense, but in real sense, we are indeed a federal system. And a federal system partakes of two levels of government, one at the union or center and several at the state or provincial level. And it is the essence of a federal system. It is the essence of a federal constitution that the Constitution, through its terms, defines the division of power between the union and the state in so many words, in very clear terms. And the judiciary is generally given the task to rectify any sort of ambiguity that may arise so far as the division of powers between the union and the state is concerned. So in a federal system, independence of judiciary, a judiciary which works independently of the control of the union or a state, is a sine qua non. An independent judiciary is most necessary for a federal system to sustain and work out properly. So we had a federal system, and both at the union and the state level, our Constitution provides for three great organs of the government, namely the legislature, the executive, and the judiciary. At the state level also, you have legislature, we have legislature, the executive, and the judiciary. Properly speaking, the union legislature is the Parliament of India, which comprises of the President, the two houses, the Rajya Sabha and the Lok Sabha. Executive is comprised of the President of India, the Council of Ministers headed by the Prime Minister, and the judiciary at the union level is in the form of the Supreme Court of India. So far as the state legislature is concerned, you have state legislature. The name of the state legislature is state legislature itself. So far as the state executive is concerned, it comprises of the governor, the state council of ministers headed by the chief minister, and at the state judiciary we have a whole system of high courts and a system of district and subordinate courts, which work under the control of their respective high courts. So we have two levels of government in a federal system. We have three organs of government at the center and the state both. And mind you, the legislature, Parliament of India, it was the legislature, Parliament of India, and the several high courts, and ultimately the Supreme Court, that from the initial days of the Constitution came into conflict with each other. And that ultimately created the situation in which the Supreme Court ultimately had to assert that Parliament cannot go beyond a certain limit so far as its power to amend the Constitution is concerned. A constitution in modern times means a constitution with certain limitations. Limitations upon the power of the executive and judiciary and the legislature as well is what is the essence of a constitutional system. And that limitation, in very grandiloquent words, were pronounced by the Supreme Court in the Keshavananda Bharati case in 1973. In fact, it was a limitation that was pronounced by the Supreme Court upon the power of the Parliament to amend the Constitution. How did it begin? How did the whole conflict begin? Let us see that. In the initial days, means from the beginning of the Constitution, from 1950 itself, we see that once the Constitution commenced, great many people, all sections of people, got a new ray of hope that our days of repression are now over. We are going to breathe fresh air in the new firmament of liberty and equality. And repression from previous times are going to be now challenged at the Supreme Court and High Court level. Right? Because our Constitution in Part 3 contains an elaborate provisions as to fundamental rights. Otherwise, constitutions generally are meant to provide for the system of government, but following the American model, our constitution makers also provided for a whole list of fundamental rights, and the essence of the fundamental rights lies in the form of equality and liberty. Several forms of equalities have been guaranteed by way of the provisions contained in Part 3 of the Constitution from Article 12 till Article 35. 6 fundamental rights are there. Right to equality from Article 14 till Article 18. Right to freedom from Article 19 through Article 22. Right against exploitation from Article 23 through Article 24. Right to freedom of religion starting from Article 25 till Article 28. Cultural and educational rights from Article 29 and 30. And finally, the right to constitutional remedies contained in Article 32, which was described by the father of the Constitution, Dr. B. R. Ambedkar, as the heart and soul of the Constitution. So, if you cast a bird's eye view upon the whole scheme of the fundamental rights, you will find that the fundamental rights is nothing but liberty writ large. Liberty rings throughout the provisions of fundamental rights. If you curtail liberty, the demand for equality will naturally arise. You are a woman, you are a girl, you won't be given equal opportunity. It will ultimately lead to the cramping of your liberty. You start demanding equality for the sake of what? For the sake of vindicating your liberty. Right against exploitation ultimately serves the cause of liberty. Right to freedom of religion also ultimately serves the cause of liberty. Cultural and educational rights means liberty in all aspects of our human embodiment. Liberty in all aspects of our human existence, be it our culture or language or education. In every manner, in every aspects of human existence, we are required to have the maximum latitude of liberty. This is what is cultural and educational rights contained in Article 29 and 30. And finally, if your rights, your liberties are threatened, then who do you approach to? The Supreme Judiciary, the Supreme Court of India. This is called right to constitutional remedies. So all the fundamental rights in a way provide for the several dimensions of liberty and provisions related to the protection of liberty. Right? So in this manner, fundamental rights are the very illustrious part of our Constitution. And fundamental rights have their importance in the fact that no law made by either parliament or a state legislature can violate the fundamental rights, can go against the fundamental rights. This is the value that has been accorded to the fundamental rights in our Constitution. And when the Constitution commenced, people started getting aware about their several fundamental rights. Sections of people who were facing all sorts of repression from the British colonial era and also since the making of the Constitution of India as well. When the task of the Constitution making exercise was still going on, in May 1949, under the Bombay Public Safety Measures Act, Bombay Public Safety Measures Act, a British time law, mind you, a British time law, Bombay Public Safety Measures Act. It wasn't withdrawn at that time. While the constitution making exercise was still going on, under this law, under the provisions of this law, the police commissioner of the Bombay state issued an order whereunder 28 communists were taken into custody without reason, under preventive detention provisions. They were languishing in jail. In the meantime, when the Constitution commenced from January 26, 1950, the their hope, motivated them. The demand for liberty motivated them, that let us make use of the provisions of the fundamental rights. And these 28 communists who were languishing in jail approached the Bombay High Court by way of Article 226 of the Constitution. And Bombay High Court, in its turn, invalidated the provisions of Bombay Public Safety Act and directed the immediate release of these 28 communist prisoners, because their imprisonment, their prolonged detention was now contrary to the provisions contained in Article 22 of the Constitution. This judgment of the Bombay High Court was pronounced on February 8th, 1950, within a few weeks of the inauguration of the Indian Constitution. So it was the first judicial blow that vindicated the fundamental rights of people, Bombay High Court's decision. Many more were to come now. Means deprived sections of society, the people who are under repression, who were facing repression on account of one or the other law of the British time or newly enacted laws, they approached the one or the other High Court or directly the Supreme Court as well, and got their right vindicated. And these pronouncements of the Supreme Court started rubbing the executive branch and the legislative branch of the government the wrong way. The executive, headed by Prime Minister Nehru, felt disturbed that courts are being very active in vindicating the fundamental rights, whereas we as executive have to take care of the protection and defense related needs of the country. We have to advance the social, economic and political justice for the people as contained in Part 4, Directive Principles of State Policy of our Constitution. So these decisions of the High Court or the Supreme Court, one after the other, started giving, bad times to the executive branch of the government, and ultimately what happened we will see in a moment from now. But let us discuss a few more judicial pronouncements that were never liked to by the executive branch of the government, and ultimately some constitution amendment was resorted to in order to avoid this conflict. The second decision, the second judgment that I am going to quote is one of Brij Bhushan versus State of Delhi, organizer case. And in the same spirit was one Romesh Thapar versus State of Madras case. These two cases were being heard by the Supreme Court concurrently, means one at the same time, and the judgment in these two cases came to be pronounced on May 26th, 1950. This was Crossroads case. Romesh Thapar case is known as Crossroads case popularly. Organizer, a magazine, a journal, and Crossroads also. These two journals were being circulated, and thanks to one or the other law, they were banned by the respective state governments. They approached the Supreme Court, citing violation of the freedom of speech and expression guaranteed to all the citizens of the country by way of Article 19, Clause 1, Subclause A of the Constitution. And finding the restrictions imposed on organizer on the circulation and publication of Crossroads, the Supreme Court said that the law that banned the circulation and publication of these two journals were violative of fundamental rights, and hence these laws were declared null and void. The third case that I am going to refer to is one of Kameshwar Singh's case. Kameshwar Singh of Bihar. Kameshwar Singh's case. In this case, on June 6th, 1950, Patna High Court gave its judgment. In fact, what had happened was that one Maintenance of Estate and Tenure Act was enacted by the Bihar legislature. The purpose of this law was to acquire the estate of several jamindars in order to hold those estates and finally to redistribute them among the needy people. So when the estate of a few of the jamindars were taken over, like the estate of Kameshwar Singh of Darbhanga estate, another estate of Mr. Vishweshwar Singh of Darbhanga, and one Kamakhya Narayan Singh's estate of Ramgarh, Bihar. These estates were taken over. And on behalf of them, Kameshwar Singh approached the Patna High Court and challenged this law. An immediate injunction was granted by Patna High Court. The Patna High Court put this law on hold, and this was kind of a success to right to property as a fundamental right contained in Article 19(1) subclause F of the Constitution. So right to property was now to become the bone of contention so far as the power of the legislature and the judiciary is concerned. This judgment of 6 June 1950 also gave bad times to the leadership of the Congress party in the state of Bihar. They turned to their central leadership for guidance, and Pandit Jawaharlal Nehru also felt disturbed because of these developments. He wrote in his letters to the chief ministers that our courts are being responsible. They are giving judgments one after the other, and they are coming in the way of our trying to implement the several agrarian reform measures and Jamindari abolition agenda. Furthermore, another development also happened on 27th of July 1950 in Champakam Dorai Rajan case, Champakam versus State of Madras. In this case, the judgment of the Madras High Court was pronounced on July 27th, 1950. Madras High Court. Champakam Dorai Rajan, because of the reservation policy of the state of Madras, was denied admission into a medical college. There was a communal government order prevailing in the state of Madras whereby seats in medical and engineering colleges were reserved for the deprived sections of society. Champakam Dorai Rajan, a Brahmin lady, stood deprived because of this reservation policy, and finding it a violation of the provisions contained in Article 15 of the Constitution, she approached the Madras High Court by way of Article 226 of the Constitution. And Madras High Court in its turn invalidated the communal general order, saying that Article 15 doesn't allow discrimination on the basis of religion, race, caste, sex, place of birth, etc. And this communal government general order is violative of Article 15 of the Constitution. Having said so, the Madras High Court declared the parts of the communal government order as null and void. And this also gave setback to the leadership at the central level. The Prime Minister Nehru, Dr. B.R. Ambedkar, they were trying now to find their ways in order to rectify the whole situation. Another judgment which deserves mention is one of Shel Devi, Shel Devi versus Chief Secretary Bihar. In this case, Patna High Court pronounced its judgment on October 13th, 1950. Patna High Court, exercising its power under Article 226 of the Constitution. The fact of this case was that one Shel Devi was in the business of publishing and circulating a journal, namely Sangram. And this journal used to make out a case for revolution in the country. Finding the publication very outrageous and one inciting public disturbance, the government of Bihar chose to put a ban on this journal, finding it violative of the fundamental rights contained in Article 19(1)(a). She approached the Patna High Court, and the Patna High Court, speaking through Justice Sarju Prasad, who was hearing the case, declared the parts of the Emergency Press Act, according to which her publication, namely Sangram, was banned. Justice Sarju Prasad, while doing so, also went on to say that since our constitution doesn't contain in Article 19 any other ground than slander, libel, defamation, contempt of court, mind you, in Article 19, Clause 2, you have several grounds like sovereignty and integrity of India, public order, contempt of court, friendly relations with foreign countries, incitement to offense, defamation, decency, morality, etc. These all are the grounds on the basis of which a state can exercise reasonable restrictions on the use of freedom of speech and expression. But at that time, in 1950, these were not the grounds. Sovereignty and integrity word was not there in Article 19, Clause 2. Public order, disturbance of public order was not also a ground for putting restrictions on the exercise of freedom of speech and expression. So, Justice Sarju Prasad said that there is no way government can put restriction on such journals, even if they create some sort of public disturbance, even if they cause disturbance to public order. So people have a now to preach murder. People have a now right to preach murder in our country, and they can get scot-free without being subjected to any sort of prosecution and punishment. So this statement of Justice Sarju Prasad was also a cause for concern. And another judgment that also came was on 16th of October, Bombay High Court. Bombay State Road Transport Corporation, Bombay State Road Transport Corporation, a body and a statutory body was created, and this statutory body had the task to nationalize the bus routes. It meant that the buses, private buses, will no longer ply in the state of Bombay, and only state-owned buses will be allowed to do their business. So this was a kind of violation. This amounted to a violation of fundamental rights of private operators contained in Article 19(1)(g). They approached the Bombay High Court, and Bombay High Court in its turn on October 16th, 1950, declared the law null and void, and hence Bombay State Road Transport Corporation was also declared null and void. Means the nationalization agenda of the government came to a halt. And one more judgment that created consternation in the government circle was the judgment of the Patna High Court on 12th March, Kameshwar Singh versus State of Bihar. March 12th, 1950. And this ultimately became the flashpoint for the deliberation in Delhi to reach to a climax. In Kameshwar Singh versus State, what had happened? That the Bihar legislature had enacted Bihar Land Reforms Act 1950, according to the provisions of which the vast tracts of the land belonging to jamindars were to be now acquired by the state. And those lands, those tracts of land were to be either used for public purposes or for the purpose of effecting agrarian reforms, like distributing the pieces of land, plots of land to the needy people. Furthermore, due to the partition of the country, refugees had also come to our country. They were residing in several parts of the country, and land was needed in order to create settlement for them. For several purposes, therefore, land in vast tracts were required to be acquired by the government. And for this purpose, Bihar Land Reforms Act 1950 was passed. This was objected to, this was impugned by Raja Kameshwar Singh at the Patna High Court, invoking Article 226 of the Constitution. And finally, Patna High Court in its judgment on 12th March 1950 declared this Bihar Land Reforms Act 1950 null and void. And mind you, interestingly enough, this law was declared null and void not because of right to property contained in Article 19(1)(f). It was declared null and void because of Article 14 of the Constitution. Because this law, as the Patna High Court said, contained arbitrary provisions. How come? This law said that once your property has been acquired, you will be given compensation. But the rate at which you will be compensation will not be uniform in the case of each individual. It essentially meant that people with higher or greater tracts of land, means big jamindars, were not to be given sufficient amount of compensation, very little amount of compensation were to be given to them. And feeling, perturbed by this law, Kameshwar Singh approached the Patna High Court, and citing the violation of Article 14 of the Constitution, Patna High Court declared this law as unconstitutional. And it is interesting to note that the judges of the Patna High Court who sit in judgment over this law approved the policy behind the land acquisition. They were not against the land acquisition as such, but they said that this law violated Article 14 because the way compensation is to be decided is arbitrary, and that's why this law was declared null and void. And the Bihar Congress leadership was in a tight spot now. It looked up to the center. Prime Minister Nehru was requested to do something, and Prime Minister Nehru, in his letters to several chief ministers, said that we will definitely do something. Courts are coming in our way of social, economic and political reforms. Dr. B.R. Ambedkar shared this view with Pandit Jawaharlal Nehru. And ultimately we will see that in order to get around all these hurdles created by judicial pronouncements, the first constitution amendment was enacted in the year 1951. But before that, another jolt also came by way of the decision of the Calcutta High Court, which later on got upheld at the Supreme Court as well. And that was the case of State of West Bengal versus Bela Banerjee. The judgment of Calcutta High Court was pronounced on March 22nd, 1951. This was the final straw that broke the camel's neck, the final setback that ultimately provoked the center to do something decisively. And they did. They did it all by way of First Amendment Act. In this case, what had happened? That one West Bengal Land Development and Planning Act 1948 was under attack. This law had allowed a statutory body to be created, and that statutory body was given the task to acquire land for the purpose of creating settlement, erecting settlement for the refugees that had come from the East Pakistan side after the partition of the country. So large tracts of land were required, but the expropriated owners, means the owner of the land whose property, whose land was taken by the government, were to be given compensation on a very low level of price. The price that prevailed in the year 1946 was to be given to them in lieu of their expropriated property. Suppose one's landowner's land is being acquired by the government in 1950, and that tract of land may be worth rupees 100, but he wouldn't be given rupees 100, he would be given rupees only 50 because that was the rate of the land, that was the price of the land prevailing in 1946. So this law was challenged by one Bela Banerjee, successfully indeed, and the Calcutta High Court in its judgment said on, as I told you, 22nd March 1951, that this law is violative of the fundamental rights of the Constitution. Later on, West Bengal government approached the Supreme Court also, and at the Supreme Court, again, they, got a defeat of sorts. This law, this judgment of the Calcutta High Court was upheld at the Supreme Court also. So these 7 judgments of either High Courts or the Supreme Court, stirred up the conscience of the leadership at the state and union level both. Prime Minister Nehru and Dr. B.R. Ambedkar both were very vociferous in their opposition to these judgments of the High Courts and Supreme Court. They felt, and quite unequivocally, that courts do not have the power to prevent us from implementing the programs for ensuring social and economic and political justice for the people. And the Union Cabinet finally directed the Law Ministry to frame a draft for Constitution amendment so that a way around could be found in order to avoid or in order to evade all these decisions of the High Courts and the Supreme Court. And in this manner, the first Constitution amendment was enacted by the Supreme Court was enacted by the Parliament of India in 1948. Constitution First Amendment Act. Constitution First Amendment Act 1951. It was still the Provisional Parliament, not the full-fledged Parliament as envisaged in the Article 79 of the Constitution. It was only a Provisional Parliament. Mind you, the Constituent Assembly, which had the task of framing a constitution for India, had started working as a Provisional Parliament, because the Constitution, when it commenced, allowed this Constituent Assembly to function as a Provisional Parliament, temporary Parliament, till the time a full-fledged Parliament comes into effect through the process of election that were going to be held soon. And as you are aware, in 1952, the 2 houses of Parliament for the first time got set up by way of elections. So in 1952, this Constituent Assembly, which was working in the form of Provisional Parliament, came to an end. So this Provisional Parliament, acting through its one single chamber, enacted the first Constitution Amendment Act, exercising its power under Article 368 of the Constitution. Article 368, as it originally stood, contained procedure for amendment of the Constitution. Amendment of the Constitution. Later on, by way of Constitution 24th Amendment Act 1971, this word power also was added in order to avoid confusion that was created by the judgment of the Golaknath case. And this power, now the Article 368 in its marginal heading says that Article 368 contains the power and procedure for amendment of the Constitution. Now this Article 368 was invoked and the Provisional Parliament enacted the Constitution First Amendment Act. The clear purpose, the very stark and obvious purpose of this Constitution amendment was to sideline the decisions of the several High Courts and the Supreme Court finally. Right? A new kind of trend was going to get established in our country, that the judiciary can be sidelined. In order to prevail upon the pronouncements of the judiciary, we can find a device like Constitution amendment. And this was done by the Provisional Parliament. As a result of the Constitution First Amendment Act, Article 31, capital A, and Article 31 capital B were added into the Constitution. Now let us try and understand this. Article 19 contains several human freedoms. Previously, the Constitution as originally understood, it contained 7 human freedoms contained in Article 19. Mind you, right to property was abolished from Article 19 1F by the Constitution 44th Amendment 1978. So there are 6 fundamental freedoms contained in Article 19 of the Constitution. 19 1F, when it was there in the Constitution prior to 1978, contained very clear provisions that all citizens have a right to acquire, hold and dispose property. Right. But at the same time, Article 31 gave the state the power to acquire property for public purposes. Mind you, all the freedoms contained in Article 19 of the Constitution are not absolute. Reasonable restrictions can be imposed on the exercise of any of these freedoms, and of course it is a subject matter for judicial review whether a particular restriction that might have been imposed on the exercise of any of the freedoms in Article 19 is in accord with the provisions of fundamental right or not. So Article 19 1F said that you have a right, you being a citizen have a right to acquire, hold and dispose property. But Article 31 said that the state exercising its power of eminent domain can acquire your property, can compulsorily acquire your property for public purposes, not for private purposes, for public purposes, for like building roads, hospitals, educational institutions, for digging canals, etc. Your property, your land or any other estate can be, means interest in land can be acquired by government. But Article 31 further said that in case of compulsory acquisition for public purposes, the state will give to the expropriated owner a compensation which will be either declared by the law itself, or the law may define the standard or the formula or the principle whereunder compensation would be awarded to the expropriated owner. So this was Article 13. So Article 19 1F was always read with Article 31 of the Constitution. Now Article 31 capital A and Article 31 capital B, which were added by the Constitution First Amendment Act 1951, Article 31A said that state can acquire any estate, means interest in land, interest in immovable property. The state can acquire any, make any law to acquire any estate, either for ever or for temporary period, in order to secure a proper management of the estate or company, etc. And Article 31B said that any law, Article 31, to tell you more detail, Article 31 capital A also said that any law providing for the acquisition of any estate or interest in property cannot be subjected to judicial review on the basis of it violating the provisions of Article 14, 19 and 31 of the Constitution. And Article 31B provided for the first time a rule that a law making provisions for acquisition of property cannot be declared land void because of being violative of Article 14, Article 19 and Article 31 of the Constitution, because once this law is placed in the 9th schedule of the Constitution, that law will gain all protection and immunity from any kind of judicial review that might be exercised by the High Court or the Supreme Court depending upon the case. 9th schedule of the Constitution for the first time was added by the Constitution First Amendment Act. To tell you in a very clear and sharp manner, the Constitution First Amendment Act 1951 added Article 31 capital A, Article 31 capital B and Schedule 9 of the Constitution. These two are important for us to keep in mind in order to appreciate the subject, which is the basic structure doctrine. Article 31B said that any law providing for acquisition of property, if it be placed in 9th schedule of the Constitution, then it will gain protection and immunity from judicial review. It also further said that if any law already declared null and void is placed in 9th schedule of the Constitution, then by a fiction of law it will get revived. So by the Constitution First Amendment Act itself, the first law that was placed on the wall or the page of the 9th schedule was the Bihar Land Reforms Act 1950. Mind you, this law had become null and void thanks to the decision of the Patna High Court on March 12, 1951. This law was void already. This law was dead already. And because it was placed in the 9th schedule of the Constitution by virtue of the Constitution First Amendment Act, it got revived. Interesting. And furthermore, any other laws which might be enacted by your or the other state legislature can be placed in the 9th schedule by way of Constitution amendment enacted by the Parliament. And once any of the law is placed in the 9th schedule, it will become immunized from any judicial review that might be subjected upon them by either High Court or the Supreme Court. So this Constitution First Amendment the Constitution First Amendment Act, in fact, at the first blush, seemed like a violation of the provisions of fundamental right itself, because the provision of the fundamental rights says that no law shall be made which is violative of the fundamental rights. Now this Constitution First Amendment Act seemed like a law violative of the fundamental rights. Let us elaborate this aspect. Part 3rd of the Constitution contains fundamental rights. These provisions are contained from Article 12 till Article 35. Though we are not that greatly concerned with all the articles, a few of the articles we will be paying our attention to only in order to appreciate the doctrine of the basic structure. Article 12 contains the definition of a state, because it was the concern of our constitution makers that the basic human freedoms, the basic liberties must remain protected from the arbitrary act or acts of a state. That's why they thought it appropriate to give a particular identity to state. The Parliament of India, the state legislature, the executive branch of the union government, the executive branch of the state government, local bodies like municipalities and panchayats, etc., other authorities which were later on interpreted by the Supreme Court to mean government control bodies, though they may not be exercising absolute exact sovereign power, but because of the greater control by the government, because of the greater share of the government, they will be also, these other authorities also will be regarded as a state. Mind you, judiciary has not been included in the purview of the state, right? Because judiciary has to act as an independent umpire and it has to declare the violation of fundamental rights at the hand of the state as null and void. That's why judiciary hasn't been included in the purview of the definition of a state. Now the most instrumental provision is Article 13 of the Constitution. Most instrumental provision is Article 13 of the Constitution. Article 13. Article 13 is of the essence here for the whole of the discussion. Article 13 says Article 13 says a state shall not make any law in contravention of or in violation of the provisions of Part 3rd of the Constitution. Simply put, no law against fundamental right. And law here has been defined to mean or defined to include ordinance, bylaw, rules, regulation, custom, and uses. Nowhere the definition of law here in Article 13 says that Constitution Amendment Act will also be a law for the purpose of Part 3rd of the Constitution. And because of this, a great deal of confusion came home to roost, and the judiciary in its turn started interpreting the provisions of the Constitution which were not very liked to by the executive and the legislative branch of the government. We will see that. So it is clear here that Article 13 provides for an embargo which says that no law against fundamental rights will be allowed. Either a law which may be existing from pre-constitution times, because in India, as you are aware, that the British introduced two kinds of laws, two species of law. One generally enacted by, exclusively enacted by the British Parliament, like Regulating Act, Charter Act, later on Government of India Act, Indian Councils Act, again Government of India Act, etc. These laws that were enacted by the British Parliament were in the form of constitutional laws, and they enacted improvement upon the previous ones always. Final constitution that was enacted by the British Parliament for India was the Government of India Act 1935. But at the same time, a system of ordinary law was also initiated by the British. Mind you, Indian Penal Code 1860 is an ordinary law. Indian Evidence Act 1872 is an ordinary law. Transfer of Property Act 1882 is an ordinary law. Shariat Application Act 1937 is an ordinary law. So a system of statutory laws or statutes were also began by the British regime in our country. So ever since the British time, we have two species of law in our country. One is the supreme law in the name of the Constitution of India, and another set of laws are several statutory laws. So whether Article 13 only consists of statutory laws when it says that no law against the fundamental right, or does a constitution amendment also form part of the purview of law as reflected in Article 13 of the Constitution? This question for the first time came up for consideration at the Supreme Court in the famous landmark case, which is Shankari Prasad versus Union of India. Shankari Prasad versus Union of India. and the judgment of the Supreme Court in this case was pronounced in 1951. In this case, the Constitution First Amendment Act was impugned for judicial review. The petitioner argued that Constitution First Amendment Act is a law and it violates, it was the argument of the petitioner, that Constitution Amendment is a law for the purposes of Article 13, and because it violates the provisions of Part 3rd, therefore this Constitution First Amendment Act is non-est. It should be declared null and void by the power of judicial review vested in the Supreme Court. Because First Amendment Act has done what? It has placed the Bihar Land Reforms Act 1950 in the 9th schedule. Bihar Land Reforms Act 1950, which was dead already because of the decision of the Patna High Court, has got a sudden revival by way of it being placed in the 9th schedule of the Constitution. So because 9th schedule has done all this mischief, because the first Constitution Amendment has done all this mischief, therefore the First Amendment Act should be declared null and void because it is against the provisions contained in Article 31 of the Constitution. It attacks or invades our property rights. Therefore, the First Amendment Act, considering it to be a law, should be declared null and void. The Supreme Court, speaking through Justice Patanjali Shastri, said that no, Article 13, though contains elaborate provision in that it says that no law against fundamental right. But law has been interpreted to mean only ordinary laws. In Article 13, the language of Article 13 is well clear, obvious, that Article 13, the law of Article 13 only means ordinary law or ordinance or bylaw or rules and regulations or custom and usages. Nowhere Article 13 says, the Supreme Court said, that nowhere Article 13 says that the law contained therein, the word law contained therein also means a Constitution Amendment law. Justice Patanjali Shastri in his words said that a Constitution Amendment Act prima facie is a law. But that is not the kind of law which has been referred to or conceived of in Article 13 of the Constitution. Article 13 only indicates of ordinary laws and all other administrative devices in the forms of rules and regulations, etc. And he went on to say that the Parliament of India, in fact the first question was, the first argument of the petitioner was that the Constituent Assembly acting as a provisional parliament didn't have the power to amend the Constitution as such. The petitioner argued that see Article 368, it contains provisions regarding the amendment of the Constitution, and it says that two houses of Parliament, one after the other, are supposed to pass a Constitution Amendment Bill which will be presented to the President of India for his assent, and through this whole exercise a Constitution Amendment can be effected. But where are the two houses? Argued the petitioner. We have only one chamber of the Constituent Assembly, and this Constituent Assembly is acting as the Provisional Parliament. So how come can this first Constitution Amendment be held valid? Because it hasn't been passed by the two houses of Parliament. This argument was very easily brushed off by the Supreme Court, and the Supreme Court said that our Constitution contains several transitory provisions. One of the provisions gave the President of India, one of the provisions, Article 392, gave the President of India the power to remove difficulties. Because the Constitution had started working, and it was felt by our Constitution makers that in the initial days of the working of the Constitution, problems are bound to arise. And in order to solve them immediately, President was given an extraordinary transitory power. So, for example, when the first constitution amendment was required to be made, though there were no two houses of parliament, but President issued an order, and in that order it was clarified by the President of India that one chamber of the provisional parliament will be considered the two houses of parliament for the purposes of Article 368, and this order of the President enabled the Constituent Assembly to pass the Constitution First Amendment. So this argument was negatived by the Supreme Court in a very easy manner. The second argument that was addressed by the petitioner was that, see, the Constitution First Amendment Act 1951 is a law, and that law has created some sort of a violation so far as our fundamental rights are concerned, our fundamental right to property are concerned. Because the Constitution First Amendment has created a device within the Constitution in the form of 9th schedule, and it says that any law violative of the fundamental rights once put in 9th schedule of the Constitution will gain all sorts of protection and immunity from judicial review, even if such a law grossly violates the fundamental right. So this Constitution First Amendment Act should be declared null and void. Rejecting this argument, Justice Patanjali Sastry wrote in his judgment in Shankari Prasad case that, see, the Parliament in the very nature of things enjoys two species of power. One is Shankari Prasad case 1951. The Supreme Court said that the Parliament is vested with two important species of legislative power. One is constituent power, another is ordinary legislative power. Ordinary legislative power. It means Parliament is interested with the task of making ordinary laws by way of the provisions of the Constitution. To tell you in detail that Article 246 of the Constitution makes a division of powers between the Union legislature and the state legislature. And Article 246 of the Constitution refers us to Schedule 7 of the Indian Constitution, and Article 246 read with Schedule 7 of the Indian Constitution leads to the conclusion that Parliament has the power to make ordinary laws in respect of the subjects contained in the Union list and the concurrent list of the 7th schedule of the Constitution. For example, POCSO Act was enacted by the Indian Parliament, right? RTI Act 2005 was enacted by the Indian Parliament, exercising its ordinary legislative power. There are several laws like Bharatiya Nyaya Sanhita Act 2023, Nagrik Suraksha Sanhita, etc. These ordinary laws are enacted by or made by Parliament in exercise of its ordinary legislative power. And the Supreme Court said in this case that apart from the ordinary legislative power, the Parliament by way of Article 368 is vested with a constituent power also. And the constituent power partakes of the power to amend the Constitution. If any amendment is to be brought about in the supreme organic law, then that amendment can be enacted by the Parliament of India in pursuance of its constituent power. So whatever is enacted by way of the exercise of the constituent power shall not come within the purview of Article 13 of the Constitution. Simply put, a constitution amendment is not a law for the purpose of Article 13 of the Constitution. And even if a constitution amendment seems to be running contrary to the provisions of the fundamental right, we will not do anything to that constitution amendment law. We will not declare that null and void because we do not have the power to do so. Whatever is enacted by the exercise of constituent amendment, constituent power is not within the purview of judicial review. And there is no provision in the constitution which makes the provisions of fundamental rights exception to the exercise of power by way of Article 368 of the Constitution. Meaning, fundamental rights are no exception to the general rule of amendment. Fundamental rights too can be amended. Because if that were not to be the case, then how come the governments of the day would go ahead and implement the social economic programs that they might have had in their mind? In order to bring into effect the several policies and programs aimed at bringing about social, economic and political justice, fundamental rights can be amended to some extent. There is no war to it as such, because such amendment is made by the Parliament in exercise of its constituent amendment power. Constitution amendment power means constituent power. So 9th schedule won the day. It was to stay, and it will create further flutters in the legal firmament of our country. 9th schedule was made use of successively by one or the other Constitution Amendment Act enacted by Parliament. This 9th schedule was originally conceived of as a device to effect agrarian reforms and zamindari abolition agenda of the government. But later on we will find that several other kinds of laws were also inserted in 9th schedule of the Constitution, and that ultimately gave a bad name to the 9th schedule. But let us proceed further. Just after 1951, what happened? 4th Constitution Amendment Act 1955 and 17th Constitution Amendment Act 1964. These two constitution amendments placed certain agrarian reforms laws, zamindari abolition laws into the 9th schedule of the Constitution so as to afford them protection from judicial review. And these two amendments became a subject matter of challenge in the landmark case of Sajjan Singh versus State of Rajasthan in 1965. So Sajjan Singh versus State of Rajasthan is the second in the series that had to consider, or that considered in fact, whether a constitution amendment law is indeed a law within the purview of Article 13 of the Constitution or not. By the Constitution 4th Amendment Act 1955, a few laws were placed in the 9th schedule that were not essentially or strictly related to agricultural or zamindari abolition, agricultural reform or zamindari abolition. One was related to railway, another was related to industry, and still another was related to insurance. So this 4th and 17th Constitution Amendment were impugned at the Supreme Court, and the Supreme Court gave its judgment speaking through Justice Gajendra Gadkar. He has given a very elaborate judgment, very logical one, Justice Gajendra Gadkar, and he has aptly analyzed the provisions of the Constitution in order to justify his conclusion. Justice Gajendra Gadkar, as he then was, said in his judgment that a Constitution Amendment Act, so basically it upheld the judgment of the Supreme Court in Shankari Prasad case. A Constitution Amendment Act is not a law within the meaning of Article 13. Fundamental rights are no exception. They too can be amended. Fundamental rights are no exception. They too can be amended. a great deal of reliance has been placed on Article 19 of the Constitution in the judgment authored by Justice P.V. Gajendra Gadkar. Referring to Article 19, Justice Gadkar says that, see Article 19, our constitution makers didn't think of making the fundamental rights paramount as such. Had it been so, they would not have placed restriction or a scope for restriction on the exercise of several freedoms contained in Article 19 of the Constitution. As you are aware, Article 19 contains 6 freedoms: freedom of speech and expression, freedom to assemble peaceably and without arms, assemble to form union, association and cooperative society, freedom of movement within India, freedom to reside and settle in any part of India, freedom to do any business, occupation and trade, etc. Previously, prior to 1978, there was right to property also. So, Justice Gajendra Gadkar says that while Article 19 on the one hand gives us several vital freedoms, but on the other hand, Article 19 also empowers the state to place reasonable restrictions on the exercise of such freedoms. It means our fundamental rights are not paramount, they are not immutable, they can be subjected to restriction. So the concept that the fundamental rights are paramount, nothing can be done against them, is neither here nor there. Fundamental rights can be subjected to restriction, and this gives us the sense that it can be amended. They can be amended too. Had it not been so, our constitution makers would have said this in so many words in Article 368 itself. Analyzing Article 368, Justice P.B. Gajendra Gadkar went on to say that, see, Article 368 creates some sort of a classification wherein our constitution makers seemed very cautious to identify the several provisions of the constitution which required or which would require one or the other method of amendment. In this, the Supreme Court says that, see, there are threefold ways our constitution can be subjected to amendment. 2 methods are the subject matter of Article 368, but at the same time there are several articles, though not many, but there are several articles in the Constitution which allow the Constitution to be amended, but those amendments are not to be considered as a constitution amendment. He gave the example of Article 4 of the Constitution and said that, see, once a state is admitted into the Union of India, or once a state is created within India by carving out territory from any existing state or union territory, Schedule 1, Article 4 says that Schedule 1 and Schedule 4 shall be suitably amended. But for this purpose, no constitution amendment would be required. Justice Gajendra Gadkar says that, that going by the provisions of Article 14, the conclusion is irresistible that certain amendments of the Constitution would not require the invocation of Article 368. They can be amended without having to go through the difficult process of constitution amendment as conceived of in Article 368. No separate constitution amendment act is required to be made. The law that created the state itself will bring about the change in Schedule 1 and Schedule 4 of the Constitution. The point is, according to certain provisions of the Constitution, Constitution can be amended, though that will not be called a constitution amendment, but it can be amended, and that will not require the help of Article 368 of the Constitution. So far as other provisions of the Constitution amendment are concerned, their amendment will definitely require the intervention of Article 368 of the Constitution. And the Supreme Court analyzed Article 368 and it said that, cast a look at the provisions of Article 368, you will find there that all the provisions of the Constitution can be amended by bringing a constitution amendment bill for the purpose and getting it passed by the both houses of Parliament. Finally, when it receives the assent of the President, it will become a Constitution Amendment Act and it will suitably amend the Constitution. The Supreme Court says that there are several provisions reflected in Article 368 regarding which our constitution makers exercised their maximum caution and said that if the Parliament wants to amend the provisions related to the manner of the election of president as contained in Article 54 and 55, if the Parliament wants to amend any of the provisions related to the power and jurisdiction of the Supreme Court and High Court, or if the parliaments want to change the extent of the executive power of the union and the state as contained in Article 73 and 162 respectively, or if the Parliament wants to amend the constitutional division of power as contained in Schedule 7 of the Constitution, or if the Parliament wants to amend the Constitution, amend Article 368 itself, then a constitution amendment bill for the purpose will be required to be passed by both houses of Parliament, and also at least half of the state acting through their legislative assemblies will be required to ratify that constitution amendment bill. Only then can it be presented to the president for his assent. So the Supreme Court said that our constitution makers were very clear-headed. They imagined the constitution amendment in a threefold manner. Certain amendments will not be regarded amendment to the constitution. Majority of the provisions of the constitution will be amended by way of Article 368, and certain others involving essentially the federal features will require ratification by a certain number of states also. So Justice Gajendra Gadkar in his judgment says that had it been the intention of our constitution makers not to make the fundamental rights amendable, then they would have included in the list of Article 368 also that either a special ratification or no amendment to fundamental rights is possible. But nowhere Article 368 gives an indicia that fundamental rights are unamendable or they require a special process for them to be amended. So in the absence of such provision, in the absence of any such provision contained in Article 368, it would be a fair conclusion to draw that Parliament has all the power to amend any part, any provision of the Constitution, including the fundamental rights. Including the fundamental rights. So it was in a manner of speaking, it was in a way the vindication of the Shankari Prasad judgment, because Sajjan Singh case judgment is in fact upholding in toto the judgment given by the Supreme Court in the Shankari Prasad case. But two important things regarding Sajjan Singh case is important to be bear in mind. Justice Muhammad Hidayatullah and Justice Mudholkar were also forming part of the Constitution bench that delivered this judgment. Justice M. Hidayatullah, though concurred with Justice P.B. Gajendra Gadkar in majority respects, in most respects, but he sounded a note of caution. He said that I am doubtful whether fundamental rights can be amended in their totality, because fundamental rights have been earned by people through struggle. It is doubtful if you can, whether you can, remove the protection given to the minorities. It is doubtful whether fundamental rights, have to be treated like all other provisions of the Constitution. Means he was skeptical whether fundamental rights too can be, amended by way of Article 368 of the Constitution in such an easy manner. If that were to be the case, then certainly fundamental protection to the people will have no meaning at all. But he largely concurred with the majority judgment. Justice Mudholkar, who was also part of the Constitution bench, his words are very prescient and remarkable. He concurred with Justice P.B. Gajendra Gadkar, but he went on to say, like in a manner of obiter, that I am doubtful whether the basic features of the Constitution too can be amended by Parliament by way of Article 368. He writes in his judgment, he writes in his separate piece of judgment, that our constitution makers have created a parliamentary form of democracy, they have created a cabinet system of government, they have enshrined social, economic and political justice for the people of India. Important fundamental rights are there in the constitution. Our constitution contains a scheme of federal system. I am doubtful whether these basic features of the constitution too can be destroyed by way of amendment. Interestingly enough, the basic feature of the constitution for the first time was this basic feature of the constitution, this word, this proverb was for the first time used by Justice P.V. Gajendra Gadkar in Sajjan Singh case. And mind you, this basic feature of the constitution became the law in Keshavananda Bharati case, but we have to reach there through a process. So that's how the Sajjan Singh judgment came to an end. The sound, the well of, the basic feature of the constitution was rung by Justice Mudolkar. It will have its full sound in Keshavananda Bharati case. We will see that. But in between, what happened? Golaknath case happened. The famous Golaknath case happened. Golaknath versus State of Punjab. 1967. An 11 judges bench headed by Chief Justice Subbarao. Chief Justice Subbarao wanted to hear the case from the very beginning. He wanted to save the fundamental rights like a crusader. He took it upon himself to sit in judgment in Golaknath versus State of Punjab. Chief Justice Subbarao. Golaknath, in fact, it was Inder C. Golaknath, IC Golaknath. To tell you an interesting story, a Bengali Brahmin, Mr. Golaknath, converted to Christianity and he left his home because he was ridiculed by his family members and neighbors. He travelled all the way through North India and arrived at Jalandhar in Punjab. And there he joined a church. He became a minister there. And he married to a Kashmiri girl there. And out of that wedlock, one Henry Golaknath, a male child, just out of curiosity, it's not part of the law as such. Henry Golaknath, another William Golaknath. These two children were born out of that wedlock. Henry Golaknath received his education in America. He returned to India to join the church. Henry Golaknath and William Golaknath duo, the brothers duo, they acquired vast tracts of land in Jalandhar. They say almost 500 acres of land. Henry Golaknath had two children, IC Golaknath, the appellant in this case, Inder C. Golaknath, and a girl, Indra Golaknath. The IC Golaknath had four daughters. Right. But that is not the part of the case law as such. I am telling just an interesting story because you have heard this Golaknath case several times. So as to enable you to retain the story in your mind, I am giving you this interesting dimension. So what had happened? The Punjab government had enacted Punjab Security of Land Tenure Act, PSLT Act. Land Tenure Act, 1953. And by virtue of the provisions of this law, the share of Henry Golaknath and William Golaknath were now reduced to 30 acres only. 30 acres to Henry Golaknath and 30 acres to William Golaknath. As a result of this effect, IC Golaknath would have got only 15 acres of land, because this Punjab Security of Land Tenure Act said that the rest of the land of this Golaknath family will get vested in the government, land acquisition, for land acquisition purposes. And this Punjab Security and Land Tenure Act also was placed in the 9th schedule, mind you, by way of the Constitution 17th Amendment Act 1978 itself. 1964 itself. I.C. Golaknath should have got himself implicated with Sajjan Singh, but for reasons not known to us, he filed a separate case, and that too after many years of time. So I.C. Golaknath presented a petition by way of Article 32 of the Constitution to the Supreme Court of India, saying that this law, Punjab Security of Land Tenure Act, is violative of my fundamental rights. And because the 17th Constitution Amendment Act has placed this law for protection in the 9th schedule, therefore this Constitution Amendment 2, being a law, should be declared null and void. The same argument as previous ones in Sankarsh Prasad versus Union of India and Sajjan Singh versus State of Rajasthan. But here this time, the father of the former Attorney General K.K. Venugopal, Mr. Nambiar, was arguing on behalf of I.C. Golaknath. He was a brilliant lawyer of his times. And Chief Justice Subbarao was hearing the case. And the first Attorney General of India, Mr. M.C. Setalwad, had resigned. His successive Attorney General was arguing on behalf of the Government of India, Union of India. Chief Justice Subbarao was very clear in his attitude from the beginning itself. He was very adamant, in fact obsessed about the immutability, inviolability of the fundamental rights. And they say he was influenced by the wisdom of Motilal Nehru, Pandit Jawaharlal Nehru, and the German scholar Dieter Konrad. And Justice Subbarao, in his many comments while the hearing of the case was going on, created consternation among the government circle. The Prime Minister Indira Gandhi also became concerned that we are going to lose the case. Our Attorney General should find a substitute for himself. So she sent her law secretary to approach Mr. M.C. Setalwad, who was in retirement, but he refused to take up the case for his own reasons, for his own private reasons. In Golaknath case, the judgment was delivered by Chief Justice Subbarao, the majority judgment. And in Golaknath case, 1967, a sort of U-turn came about. The Supreme Court, in its majority ruling, declared that fundamental rights are primordial, they are transcendental. They cannot be overridden or they cannot be amended. They cannot be amended. Fundamental rights are essential. They cannot be amended as such. The power of the Parliament by way of Article 368 doesn't extend to the provisions of Part 3rd of the Constitution. So, the conclusion was that the law contained in Article 13 is, or the law, Constitution Amendment law made by way of Article 368 is the same law as spoken of in Article 13 of the Constitution. So, a Constitution Amendment is also a law, and if it violates the fundamental rights, then by virtue of the provisions contained in Article 13, the same is going to be declared null and void. Therefore, Justice Subbarao declared that all the previous Constitution amendments which brought about insertions in Schedule 9 of the Constitution were null and void. Constitution First Amendment Act 1951, Fourth Amendment Act 1955, 17th Constitution Amendment Act 1964, these all are violative of the fundamental rights contained in Part 3rd of the Constitution. That's why they deserve to be declared null and void. But the Supreme Court said in this case that we are not going to declare them null and void because changes have been brought in, things have settled now, and in a society governed by rule of law, nothing should be done to turn things upside down. We do not want to dislocate things because they have got settled. So applying the doctrine of prospective overruling, interesting, doctrine of prospective overruling, the Supreme Court said that any constitution amendment after the judgment of the Supreme Court in Golaknath case, that is from February 27th, 1967, if any constitution amendment is enacted so as to insert any law in the 9th schedule which is ultimately found to be violative of fundamental rights, that will be declared null and void from the beginning itself. But prior to this judgment, if any constitution amendment has been made, and in fact they had been made, First Act, Fourth Act, Seventh Act, these all deserve to be declared null and void, but we will not declare them null and void because let the sleeping dogs lie. Why disturb them? And the Supreme Court invoked here the doctrine of prospective overruling. This doctrine was for the first time initiated by the American Supreme Court in Great Northern Railway Company, Great Northern Railway versus Sunburst Oil and Refinery Company in 1932. The American Supreme Court had developed this doctrine of prospective overruling, and it was utilized by our Supreme Court to great advantage, and the Supreme Court said that all these previous amendments, though they deserve to be declared null and void, but they will stay, they will sustain, they will be allowed to continue. But if any further amendment is made after February 26, 1967, then by way of judicial review, that constitution amendment, which may be ultimately found to be violative of the fundamental rights, can be declared null and void. This was like a setback to the then government led by Prime Minister Indira Gandhi. And it was like a conflict sort type of a situation. The Parliament was adamant to assert its power. The government, the executive branch led by Prime Minister Indira Gandhi, was adamant to assert its power, and the Supreme Court at the same time was equally adamant in its spirit to protect the fundamental rights, to assert its power. Parliament responded at the initiative of the Prime Minister. Parliament responded and constitution amendment were enacted. Constitution 24th Amendment Act 1971, Constitution 25th Amendment Act 1971, and Constitution 29th Amendment Act 1972, because these three constitution amendments that we have to concern ourselves with in order to appreciate the basic structure doctrine. Constitution 24th Amendment Act brought about changes in Article 13. In Article 13, Clause 4 was added. In Article 368, Clause 3 was added. The marginal heading of Article 368 was also changed a little bit. Article 13, Clause 4 now says, means as a result of the changes made by this Constitution Amendment Act, Article 34 clause, Article 13 clause 4 now says that a law made under this article shall not be same as a constitution amendment law made by way of Article 368. And Article 368 clause 3 now says that a law made by way of the exercise of amendatory power shall not be the same law as conceived of in Article 13 of the Constitution. It means that Article 13 will not affect a constitution amendment made by way of Article 368 of the Constitution. Article 20, Constitution 24th Amendment also brought about certain changes in the marginal heading, as I had told you in the very beginning, that Article 368 as it originally understood contained only provisions for procedure of amendment. Now another word, power of amendment, was also added, power and procedure to amend the Constitution. And what was the reason for this little somersault? The reason was the judgment of the Golaknath case. In that case, Justice Subbarao, Chief Justice Subbarao had said that see, Article 368 of the Constitution doesn't give power to any organ of the government to amend the Constitution. Article 368, he said, contains only provisions regarding the procedure to amend the Constitution. There is no power that belongs to any organ of the government so as to bring about an amendment into the Constitution. And he said, he went on to say in that judgment of Golaknath that if you must amend the Constitution, then you can perhaps utilize entry 97 of the Union list of the 7th schedule of the Constitution, which contains about the residuary power of the Parliament. So you utilize the residuary power of the Parliament and follow the procedure given in Article 368, only then can you amend the Constitution. What a superficial judgment reasoning was given by Chief Justice Subbarao. Anyhow, the Parliament now clarified the position by way of this Constitution amendment that Article 368 is not only about procedure for amendment, it also contains power for amendment as well, and the power belongs to the Parliament of India. Furthermore, this Constitution 24th Amendment also brought about change in Article 368 to the effect that the President will no longer have the power to exercise veto over a Constitution amendment bill. The President will be now constrained, duty bound in fact, to give assent to a Constitution amendment bill. So this way the office of the President was, devalued to a great extent. Regarding ordinary bill, mind you, President can well exercise the power of veto. He can send back the ordinary bill to the Houses of Parliament for reconsideration. But regarding a Constitution amendment bill, he doesn't have such power anymore. He cannot return the bill for reconsideration to the Houses of Parliament, because Article 368 in its amended form says that President shall give his assent to a Constitution amendment bill of a necessity. He has no way out. So this amounted to a devaluation of the office of President, but so be it. Let us move on. Constitution 25th Amendment Act 1971, it also brought about certain changes. And this Constitution 25th Amendment Act 1971 was motivated by the judgment of the Supreme Court in R.C. Cooper versus Union of India case in 1971. In that case, the Supreme Court, which is famously known as bank nationalization case, the Supreme Court had said that if you acquire the estate of any person, means property of any person or interest or right in property of any person, then the state is duty bound to give him rateable compensation, means compensation at market value, right? And in order to obviate the effect of that judgment, the Constitution 25th Amendment was enacted by the Parliament of India. And it brought about certain changes in Article 31 so as to ensure that only an amount is given in the form of compensation. What amount? There was no indication as such. And furthermore, this Constitution 25th Amendment also added Article 31C, capital C in the Constitution, which provided, and it still provides for that, if Parliament or a state legislature moves to make any law so as to put into effect the provisions of the directive principles of state policy as contained in Article 39B and C, then such a law shall not be subjected to, cannot be impugned on the basis of their alleged violation of Article 14, 19 and 31 of the Constitution. Means if a law is being made ostensibly to give effect to Article 39B and C, then that law, even if contrary to fundamental rights, will not be declared null and void by courts. So it was in a way giving privacy to a small part of directive principles of state policy, primacy over the fundamental rights, which idea was rejected by the Supreme Court in Chakam D Ran case in 1951. In that case, the Supreme Court had said in April 1951, State of Madras versus Chakam D Ran case, that if the State of Madras has given reservation so as to fulfill the objectives contained in Article 46 of the Constitution, and mind you, Article 46 says that it shall be the duty of the state to promote the economic and educational interest of the social of the weaker sections of society, particularly the members of the scheduled castes and scheduled tribes. In order to fulfill those objectives, the State of Madras had enacted that communal general order which gave reservation to certain sections of backward classes in the State of Madras, as a result of which Chakam D Ran was deprived of her rights, and she had approached the Madras High Court, and Madras High Court in its turn on July 27th had declared the communal general order as null and void, and that's how the State of Madras, after receiving a state certificate of fitness, approached the Supreme Court of India and filed an appeal there at the Supreme Court. In April 1951, the Supreme Court came up with its judgment and said that there may be situations where, in order to give directive principles of a state policy, a law will have to be made by the state. And if that law comes in conflict with the provisions of fundamental rights, then a question may arise that which one has to be given primacy, whether the directive principles of a state policy or the fundamental rights. And the Supreme Court said in Chakam case that in such a situation of conflict, fundamental rights will be given primacy. Directive principles have to run as subsidiary to the fundamental rights. That was the settled law. And because of that, Constitution First Amendment Act had also made changes in Article 15 in order to ensure that the Madras law stayed the field. So here, in violation of the Chakam law, the Parliament, by way of 25th Amendment 1971, made certain provisions of the directive principles of a state policy primary to the fundamental rights. And this was also challenged before the Supreme Court. 24th Amendment, 25th Amendment and 29th Amendment was also challenged at the Supreme Court by way of Article 32 of the Constitution. What was all about Constitution 29th Amendment 1972? This Constitution Amendment had placed the Kerala Land Reforms Act in its amended form, 1969, 1971. These two amendments of the Kerala Land Reforms Act were placed in the 9th schedule of the Constitution, as a result of which one priest, Keshavananda Bharati, felt violated, and he approached the Supreme Court by way of Article 32 of the Constitution. So in fact, in Keshavananda Bharati case, which brings us directly to our basic structure doctrine, in this Keshavananda Bharati case, there were 6 writ petitions. Keshavananda Bharati case, famously known as fundamental right case. State of Kerala, 1973. A 13 judges bench had to consider the constitutional validity of Constitution 24th Amendment, 25th Amendment, 26th Amendment, 29th Amendment. I am omitting 26th Amendment because that is not our present concern here. So these three amendments were the subject matter of the challenge, main challenge in the Keshavananda Bharati case. And thanks to the brilliant argument addressed by the legendary lawyer Nani Palkiwala and countered by H.M. Sirvai, the Advocate General of the Maharashtra government, this Keshavananda Bharati case had a marathon session consuming upwards of 60 days time of the Supreme Court. On a daily basis, argument were addressed, and through a majority verdict of 7-6, the judges declared the doctrine of the basic structure of the Constitution. In this case, ultimately, thanks to the wisdom and the brilliant argument presented by Mr. Nani Palkiwala, the Supreme Court was called upon to consider the validity of the 24th, 25th and 29th Amendment of the Constitution, and also to review the judgment of the Supreme Court in R.C. Cooper versus Union of India, Golaknath versus State of Punjab, and previous to Sajjan Singh and Sankri Prasad case also. So in this case, finally it became a question that whether the Parliament has the power, unlimited power to amend the Constitution. Can an amendment abrogate in totality the provisions of all the fundamental rights? This was the final question. This was the ultimate question that was answered to by the majority of judges. While giving the judgment, Chief Justice S.M. Sikri, Justice Grover, Justice Shel, Justice N. Ray, they wrote their separate judgments, but the majority concurred on this one point, that the Parliament doesn't have the unlimited power to amend the Constitution, because there is a basic structure that has to be always respected, that has to be kept in mind every time the Parliament gets to amend the Constitution. Justice S.M. Sikri, analyzing the judgment of Sajjan Singh case, says that, see, there in Sajjan Singh case it has been said that Article 368 presents sort of a classification whereby it stands totally manifest that there are certain provisions of the Constitution which require separate method for their amendment, because they are very important ones. He said that the manner of election of president cannot be amended easily, because Article 368 says that it is not like any other provision of the Constitution which can be amended by the principal method contained in Article 368. If you want to amend the manner of the election of the president, then you will have to have a constitution amendment will pass by the houses of parliament, and also at least half of the states of India acting through their state legislative assemblies will have to ratify it, because the manner of the election of president cannot be subjected to amendment in such an easy process. And Justice S.M. Sikri went on to ask the pertinent question, what about Article 52, which contains provisions regarding the president? There shall be a president of India. Can the Parliament amend it? On the one hand, Article 368 gives the indication that if you want to amend the manner of the election of the president, then go through a special process, have the states on board as well. Only then can you amend the manner of the election of president. But what about the office of the president? What about the post of the president itself? Can it be amended? Was it not in the mind of our constitution makers that on the one hand they were giving procedure for amendment as relates to the manner of election of president? But what about the office of president? Can it be done away with? Can it be abolished by way of constitution amendment? Justice S.M. Sikri gives a very appropriate answer, that our constitution makers were having in their mind a very clear concept, that majority of the provisions of the constitution can be amended, but there are certain provisions which are meant to endure for all times to come, and that's how there is an implied limitation contained in Article 368 itself. office of the president cannot be done away with. The democratic republican form of the government cannot be done away with. So he basically relied upon the wisdom, the piece of wisdom set out by Justice Mudholkar in Sajjan Singh case. He referred to the piece of the judgment written by Justice Mudholkar in Sajjan Singh case, and he said that our constitution makers had indeed conceived of certain features of the constitution which are to be beyond the reach of the parliament. There are implied limitations so far as the amendment power of the parliament is concerned, because you cannot amend the office of the president in such a manner to destroy it or in such a manner to do away with it completely. There are certain implied limitations. Not all the provisions are susceptible to amendment as such. They have to endure, they have to remain intact forever. And that's how the doctrine of the basic structure of the constitution came about. The majority of the judges concurred that there are certain provisions in the constitution that have to be always there. And majority of the judges in their judgment have said that the parliamentary form of government, the independence of judiciary, federal features, sovereign and democratic system, republican form of government, the gist of the fundamental rights, etc. They are so important, they are so vital, they are so basic and fundamental that they cannot be destroyed by way of amendment. If you want to amend the constitution by way of Article 368, permission is there. But permission is not there to amend the constitution in such a manner as to destroy any of the elements of the basic features of the constitution. Because if you amend the constitution in that way, then what will become of the constitution itself? Justice H.R. Khanna, contributing his part, said that every time you amend the constitution, the original constitution must survive. It means only a limited power of amendment is there in Article 368. The basic features of the constitution, the basic features of the constitution are beyond the reach of parliament. Thanks to the successive decisions of the Supreme Court, it has now become clear that whatever elements or whatever principles form part of the basic features of the constitution, they can be amended so as to improve their quality. But if the purpose is to destroy any of the elements of the basic feature or basic structure, that permission is not there. That constitution amendment is bound to be declared null and void, being violative of the fundamental rights, being violative of the basic structure of the constitution. So that's how the idea of the or the doctrine of the basic feature of the constitution emerged, and it has been a watershed development in the history of India, that judiciary saved the constitution from the transient majoritarian attack by parliament. Basic structure doctrine survived scrutiny further. It was in fact an authoritative formal confirmation by the Supreme Court that basic structure doctrine will stay. It is here to stay forever. 3 later cases: Indira Gandhi election case, Indira Gandhi versus Raj Narayan case, 1975, Minerva Mills case, Minerva Mills versus Union of India case, 1980, and Vaman Rao case. These 3 latter cases in a way upheld the basic structure doctrine. They for the first time authoritatively applied the basic structure doctrine in order to consider the validity of constitution amendment. The most recent case is I.R. Coelho versus State of Tamil Nadu. (2007). Madras State, as it was previously known, Tamil Nadu State, later on, enacted a Gudalur Janman Abolition Act 1969, and this law was placed in the 9th schedule by way of Constitution, 34th Amendment Act 1974, just 1 year after the Keshavananda judgment came. And the validity of this constitution amendment was being considered in IR Coelho State of Tamil Nadu by a 5-judge constitution bench. And that 5-judge constitution bench noticed in fact that thanks to the decision of the Supreme Court in Vaman Rao case, wherein it was said that it is doubtful whether a law contained in 9th schedule after 24th of April 1973, if it violates the basic structure of the constitution, would be allowed to continue. Would it not be declared null and void because it violates the basic structure of the constitution? So this question was referred to a 9-judge bench in IR Coelho case for state of Tamil Nadu, and the final judgment now says that a law placed in the 9th schedule of the constitution after the Keshavananda Bharati judgment on April 24th, 1973 is subject to judicial review. Means after the judgment of the Supreme Court in Keshavananda Bharati case on April 24th, 1973, if a law by way of constitution amendment has been placed in the 9th schedule, then that law can be subjected to judicial review on the limited ground that whether it violates the basic feature of the constitution or not. If it does, then it matters not whether it has been placed in the 9th schedule, it can be declared null and void. So 9th schedule now no more gives protection from judicial review after April 24th, 1973. In Keshavananda Bharati case, the constitutional validity of the 9th schedule was upheld, but the latter decision in IR Coelho state of Tamil Nadu now says that any 9th schedule law can be subjected to judicial review on the limited grounds that whether it is in accord with the basic feature of the constitution or it is violative of the basic feature of the constitution. If latter be the case, then the same can be declared null and void. So this basic structure doctrine has become a permanent feature of the corpus juris in our country. Whether you like it or not, it will stay. It has come to stay. And several times the Supreme Court has invoked this basic structure doctrine to declare the constitution amendments null and void. The most recent example was that Supreme Court Advocates on Record Association versus Union of India, in which the Constitution 99th Amendment Act 2014 was declared null and void as being violative of the basic structure of the Constitution, because that hampered the independence of the judiciary, which the Supreme Court says that form parts of the basic feature of the Constitution. So basic feature of the Constitution has many flaws, but it has many merits, and in comparison the merits triumph. We like it in the most part, but we dislike it also. I too have certain personal objections, which I will be referring to in our later discourse. Till then, thank you all. For such informative, edifying videos, you may subscribe to St. Peter's Law Academy. Thank you for today. Thank you.